natin. Ito lang. Papatik ito para iya. Sempit Pak. Tip na lang Pak saya. Lagay mo siya. Masyadong makapal na. Isa lang. Hawakan mo.
Check. Check A. Check audio. Swap. Check audio. Check swap A. Check audio. Check. Check audio. Check.
Good morning, everyone. Please all stand for the members of the Judicial and Bar Council. We have Honorable Maria Milagros N. Fernan Cayosa, Honorable Jose V. Mejia, Honorable Justice Aurora Santiago Lagman, Honorable Justice Angelina Sandoval Gutierrez, Honorable Menardo I. Guevara, Please remain standing for the centennial prayer for the courts, national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our Supreme Judge. We humbly beseech you to bless and inspire us, so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Lubang hinirang public interview of applicants for the position of Associate Justice of the Supreme Court to be vacated by Associate Justice Martin S. Villarama Jr. on January 16 this year is now declared open.
Your Honors, the candidates to be interviewed this morning are the following. We have Attorney Santos B. Bisquera of the Bisquera Balagtas Law Center and Dean, University of Manila. Then we have Secretary of Justice Alfredo Benjamin S. Caguiwa. Number 3, Sandigan Bayan Presiding Justice Amparo M. Cabotahitang. And Congresswoman Quinchona Cruz Gonzalez, CBAC Party List. May I request Secretary Caguiwa, Presiding Justice Cabotahitang, and Congresswoman Gonzalez to stay in the holding room while the interview of Attorney Bisquera is being conducted. Thank you so much, sir. Attorney Bisquera, please occupy the hot seat.
Good morning po, Justice.
You are now ready for interview. So may I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning. Good morning, Dean Bisquera.
Good morning po, ma'am.
In your personal data sheet, it states that you turned 68 last October 2015. May I know what made you decide to apply at this stage in your life for the position of Associate Justice of the Supreme Court?
Your Honor, I applied for the position of Associate Justice Supreme Court because I feel that my 45 years as a corporate business, senior business manager, and also my being a professor in the Graduate School of Business of both UP and De La Salle would introduce a new perspective, an additional perspective in the resolution of mercantile law cases and other business-related cases before the Supreme Court. So I feel that while I've been a perennial candidate here, and I remember you were already in the panel in 2012 when I sat here, I still feel mentally and physically strong to be able to contribute to the jurisprudence of the Supreme Court, especially in the areas of my expertise in the field of business and commerce.
Thank you, Dean. The Supreme Court has administrative supervision over all lower courts and the personnel. Could you be more specific? What would be your cause, or what would you hope to accomplish within less than 2 years should you be appointed, since the mandatory age of retirement is 70?
Your Honors, the major strategic issue on the judicial system in the Philippines revolves around the speedy disposition of justice. And without casting any aspersion on the ongoing efforts, because there have been major efforts to accelerate the judicial process, perhaps the Supreme Court needs a fresh look from somebody like me who's had 45 years in the private sector, especially specializing in the area of systems and procedures. In my own participation as a practitioner, I have seen 1,001 nooks and corners of slowing down of the process, and while almost all members of the Philippine Bar, especially the practitioners and the judges and justices, can see it, there have not been any aggressive effort to smoothen the flow. And somehow my training and experience in the private sector using the concept of mapping and systems flow charting, and also the concept of accountabilities and information and control would be a significant contribution even for the short time that I may be in the Supreme Court, Your Honors.
I noted that you have been in the academe for quite some time. Could you specify a particular project or undertaking that you have successfully engaged in the academe, which would show that you do have the expertise to come up with a mapping system that would help improve in the administration of justice?
Your Honors, in the area of the academe, the application of mapping may be marginal. But I remember Justice Gutierrez was still active in the Supreme Court when I was appointed Dean of the College of Law of the University of Manila, who was about to lose its permit because of 4 years zero performance in the bar. On my second year, and it has not been overtaken, we have registered 75% passing in the bar. And everybody, including the Supreme Court justices, were kidding me and say, Dean Bisquera, what miracle did you do for UM? Up to now, Justice, that has not been matched. Unfortunately, I have not produced a bar top notcher from UM yet. You know, it may happen somehow.
Thank you, Dean. Now, in your personal data sheet, you also disclosed that there was a bar discipline case filed against you in 2007 by a certain Emmy Marahay. Could you tell us something about this case? I know that this has since been dismissed or decided, but perhaps you might want to inform us about the details.
Yes, Your Honor. Your Honor, this is a labor case where the employees of Motorola were retrenched, and there was a very crucial issue on whether, in spite of the 2 months for every year of service separation pay they were given, whether they're entitled to a vested fund that gives them an additional 1 month for every year of service. I fought this particular case up to the Supreme Court, and it is not only Ms. Marahay that filed a case. There were 4 others. Your Honors, it was a simple case when they didn't even want to pay the acceptance fee. My acceptance fee was essentially only 5,000. They paid me initially 500 with the commitment that they will pay the balance when I win the case, and I won the case after 7 years. These 5 people simply ran away with their proceeds, and when I was trying to collect, they went to the IBP to file a disbarment case against me, so they are not, they cannot pay. The Supreme Court, when it reached the Supreme Court, had a very complimentary decision saying Dean Bisquera gave his best opposite the biggest law firm in the Philippines, and he won the case on merits, and therefore a 5,000 acceptance fee where only 500 was given is heavily reasonable, and so the disbarment case has no meaning at all. This is the Supreme Court talking, Your Honors.
My final question, Dean Bisquera, in as much as in 2012 we extensively interviewed you, I just want to find out, what would be your legacy if given the opportunity to serve in the High Court?
Your Honor, I will be very candid in saying that I am a realistic person. I know that getting government positions is not purely on the basis of merits on the table. There are a lot of unmentionable factors that can happen. But if by chance of fate and the blessing of the Lord, I sit in the Supreme Court for 2 years, Your Honor, I'd like people to remember this was the fellow, the only certified public accountant that ever landed in the Supreme Court. And it was not only his title, he was the one who contributed to a smoother flow and fast disposition of cases. If that is the only thing that they will say when they put me 6 feet under the ground, I would probably be smiling, Your Honor.
With that, Dean Bisquera, as I mentioned, it was my last question.
Maraming salamat.
Maraming salamat, and I wish you luck. Salamat po.
Thank you so much, Attorney Cayosa. Thank you, Dean. May I request now Attorney Mejia to continue?
Thank you, Justice Gutierrez. Good morning, Dean Bisquera.
Good morning
Just
po.
a few questions, Dean Bisquera. Your PDS indicates that you are deeply involved in legal education.
Yes, Your Honor.
And how do you assess the current state of our legal education?
Your Honor, it is since I am a strategic man from the business point of view, and I applied the analysis of strategy in relation to the law schools. It is to be candid about it. The law schools can be somehow cut off by way of saying UP, Ateneo, and San Beda, and probably just to make Justice Gutierrez a little more pleasant, let's include the University of Santo Tomas, where I also became a faculty member. I have a feeling, Your Honor, that the market is totally different because these 4 schools have full-time students with all the resources that they can afford. And one time when I asked one of the deans of these law schools on how I can improve, the lot of the University of Manila Law School said, Dean, huwag mo nang ambisyonin na talunin kami because we get the best quality with all the resources. You get, essentially clerks in offices, government institutions, low-level police officers. And so if you can pass them on the first sitting in the bar, you have made your mission. You have allowed them to at least become good lawyers because they have the minimum. So forget about matching our capability at the Ateneo, at UP, San Beda, and UST. And I can only blink and say these are the realities of legal education in the Philippines. On the other hand, Your Honor, there's one little joke that I always get even when Justice Gutierrez was chairman of the bar examination. Your Honor, if you remember, they were kidding me about abolishing taxation because the biggest mortality, I guess, is mercantile on taxation by statistics. And they were saying only Dean Bisquera knows how to teach taxation among the deans, so let's abolish taxation. But somehow along the line, these are some of the inconsistencies in the way we looked at the bar subjects. I was the first dean to support Justice Abad when he introduced the MCQ, the multiple choice methodology. I felt the working students have a greater chance because it eliminates the question of grammatical errors, poor handwriting, and so on. I don't know why there have been a slow return to the essay type because there was no intention to abandon the essay type, but a balancing of multiple choice questions and essay type. Final point, Your Honor. We have law professors who do not know how to teach. And the proliferation of green jokes and stories that are irrelevant to the subject continue to bug the law schools.
Thank you. On a related matter, should you have an opportunity, Dean Bisquera, to introduce innovations in the admission of law graduates to the bar, what would those innovations be?
I like the idea that most states in the United States have now in place that the examination comes in 2 parts. Somehow it's essentially the MCQ on the first part to measure the minimum requirements, and it can be taken somehow in most of the states at the schedule of the candidate, and then the second half becomes the essay type. This may really help a lot of working law students because they will not be pressured to go into the bar review the way we are doing it right now. And so they can take the bar examinations at their own pace and still hope to pass the bar. By the way, Your Honor, I was a working student and I entered law school as an old man at 40 years old and took the bar one take. Disappointed because I did not land in the top 10.
Okay, you mentioned that, your PDS also indicates that one of your areas of expertise is taxation.
Taxation, yes.
Are there any current policies of the BIR that you find legally questionable?
In terms of legal issues, Your Honor, candidly none. The 1997 amended income tax, the National Internal Revenue Code, plug in a lot of loopholes that I'm very familiar with in terms especially of executive compensation. Let me share with you some of the inputs that we were doing. Meaning I was the beneficiary of that, and it was legal. There was a time I was working with a big corporation, and they said, okay, Joe, you have this compensation, but we'd like to increase it. We will only declare 40%, 60% of it, the 40% will pay it to you some other way. You know what they did? They opened a credit card facility for me. They deposit the 40%. It's not subject to withholding tax. It is not even declared. And therefore, that kind of mechanism was spread all over the place. Fortunately, when the tax code was amended, they consulted one of the leading auditing firms in the Philippines, especially the retired CPA lawyer said, the president then, I will not mention his name, said, tulungan nyo naman ng bayan para mag-improve yung ating tax collection system. Yung tinip nila yung mga ganong mga tax evasion cases, which was not evasion at that time because the law did not prohibit that. Today, no more. So as a tax professor, when people ask me how can they save taxes, I said, you better pay your taxes correctly because the government needs the money that should come back to us. And there is no room for us to cheat the government this time.
Thank you. That was my final question. Good luck, din, Bisquera. Thank you, Madam Chairman.
Thank you so much, Attorney Mejia. May I request then our new member acting in an acting capacity representing the Secretary of Justice, Attorney Guevara.
Thank you, Justice.
To continue.
Thank you, Justice. Good morning, Dean.
Good morning po.
I had the opportunity last night to take a look at your personal data sheet. I'm sorry that much of the documents that were intended for this interview were delivered to me quite late in the day, but I took the evening to go over all the papers submitted, and knowing that you would be first, I took a look at your personal data sheet and noted some observations here. This would go way back to your educational background. I hope you don't mind.
No, I don't mind.
Yes, because I noticed that you graduated valedictorian from the University of the East in your Bachelor of Laws degree.
Yes, Your Honors.
Cum laude and valedictorian. And also from the same university, much earlier when you took up accounting, you graduated actually summa cum laude. And even got this award, Citizenship Award for outstanding performance in academics. However, I noted that when you took the bar exams, you obtained a rating of 76%. And when you took the CPA board exams, you got a rating of 77%. Considering the very high academic performance that you had while you were in the university, could you please explain to me this sudden downturn in your performance during the bar and the board exams?
Marami pong salamat for asking that question, sir. First of all, I always say that the Lord has a way of reaching out to you. And so I was expecting to be in the top 10 in both the CPA and bar exams, and I did not with those grades. And if you scan the grades, the subjects where I'm supposed to make a real showing is where somewhere along the line it didn't happen. My explanation, Justice, is this. The Lord is a way of reaching out to you and say, bawas-bawasan mo naman ang yabang mo. Lahat na ng klase ng honor binigay ko sa iyo. Pati ba naman yung CPA tsaka bar, magyayabang ka na naman. It allowed me to be a little more realistic that there are challenges in life where you cannot win all the time. That there are certain situations where you bow and say, that is it. Now, in the bar examination, what is amazing is I took the bar when I was 45 years old. And even my professors in the political science who became my mentors in the College of Law said, Dean, Nung ikaw estudyante namin sa political science, plot 1, ka-prelims, midterm finals. Pero that was 25 years ago. Nandyan pa ba ang utak mo? And I was smiling and said, "Sir, subukan po natin." Opo. So that is the only, and my reaction is, in spite of this frustration, after the announcement of the bar was made, I think I'm the only new lawyer who became a bar reviewer immediately 3 months after my passing the bar. And this is against the objection of another lawyer, the president and owner of the University of Manila, who at that time threatened Dean Moralde to be fired if there is any single bar reviewee who will complain about anything that I do in the bar. Your Honor, I did not only continue to become a bar reviewer for years in many schools, I became the dean of that school in 2004. And when I was offered that, I reminded the president, said, "Weren't you objecting to my being even a law professor?" And so he said, "Kalimutan mo na nga yun, Dean. You have proven your word." So to my mind, Your Honor, I submit with all humility, I did not succeed in my objective in the CPA and bar examination. And I accept that.
Thank you, Dean. It seems that you'll be turning 69 this year.
68 po kalag, no, October.
Yes, so this year you'll be turning 69.
Sa October po.
Yes, that's right.
Please allow me to enjoy the benefit of the period.
Exactly. So, and you were saying earlier that within the less than 2-year period remaining, just in case you're appointed to the highest court of the land, you'll be able to contribute what you had gained during your 45 years of private law practice and legal education. So, can you give us an idea by probably mentioning 3 specific measures that you could propose to speed up the civil litigation process?
I will bore the 3 members of the panel who were already here in 2012 when I mentioned this. There are a number of nooks and corners in our rules of court that we have already admitted to be redundant, and we continue to follow it. For example, Your Honor, in the rules of court, if a trial judge makes a decision, there is a need for us to file a motion for reconsideration in order for the action to continue. Without the motion for reconsideration, the next step, for example, on appellate jurisdiction, will not happen. Your Honor, I wonder if we apply statistics of the 1,000 and a couple of thousands of trial judges in the Philippines, how many of them have reversed their decision on the basis of motion for reconsideration? Let's be very realistic about it. A judge is presumably somebody who studies the full details of his case and would not render a decision based on whimsical and an arbitrary basis, because he will be exposed to the ridicule and censure of the appellate courts up to the Supreme Court. And so it may be interesting to note that in my own practice, I have never won a reversal of a decision where I filed a motion for reconsideration. So one of the questions I'd like to raise is, what if we remove the motion for reconsideration, which we already did, or we have already done, in the cases of labor disputes? There is no MR on the arbiter's decision. And so we are already admitting that in the area of speed of execution, we can definitely improve the speed by just eliminating the MR, because the MR will call for a reply from the other party, and it really prolongs the process. And among smart practitioners, they make use of this precisely to tire the opposing party, who may not have the financial resources for a prolonged trial. And so I would immediately move. Even now, I probably, with or without any result of this one, I will probably move to the Supreme Court to propose the amendment of the rules to eliminate all the MRs. Second point, Your Honor, and this is where the Chief Justice reacted when I mentioned this, and I wouldn't mind repeating this. We have 15 justices of the Supreme Court, and if we eliminate the Chief Justice, we have 14 justices up there. On the other hand, if you looked at the hierarchy of courts, we have, of course, the appellate courts, and then we have the trial courts. My question is, why have we not organized the courts into a certain accountability, where out of the 14 judicial regions, we now make one justice of the Supreme Court fully accountable, with the complement of, who knows, 2 or 3 or 4 justices of the Court of Appeal. So you will have, for example, in Region 1, a complete hierarchy of justices, and therefore, if there are any of the unnecessary filing of appeals, certiorari's, and so on, these are initially screened within that particular regional responsibility. Now, the reaction I got was, Dean, the justices of the Supreme Court have already so much load, and I wanted to react, but in a public forum like this, you don't argue with the Chief Justice. And so I kept my mouth shut, but may I be allowed now to speak and say, probably it's like the question of the chicken or the egg. The reason why so many cases go up to the Supreme Court is because we don't have the screening process and accountabilities from a Chief Justice, from a Associate Justice of the Supreme Court, accountable for a region, complemented by certain designated Court of Appeal justices. And now we make sense in appointing executive judges of the regional trial courts and metropolitan trial courts. There's going to be a team that will be accountable, and the measurement of the disposition and quality of the decisions will be now within a certain structure. We don't have the structure right now, Your Honors. And if this causes me my not even being voted upon by any of you, I surrender. But I will not rest this case until somebody realizes that that is how the management ball game is played in the private sector. Everybody is accountable for everybody, and the monitoring of performance is closely within the area of responsibility centers.
Thank you, Dean.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue.
Thank you very much, Justice Gutierrez, Attorney Santos Balagtas. Good morning.
Good morning po.
Now, as you have stated before and as shown by our records, we have extensively interviewed you on October 23, 2012 in connection with your application also for a slot in the Supreme Court. So I have a very few questions now. Attorney Santos, how is your health? We do not have any record of your latest medical certificate.
Your Honor, I am a triple bypass survivor 7 years ago.
Yes.
And the doctor said, Dean, the cycle is 5 years, 5 years. So I'm running on my second year on the extra period.
Yes.
And I'm not, I have not had any signal from my cardiologist. I will have to go to another cycle of bypass operations. In fact, Your Honor, this is one of the monuments in the way I care for myself. At the age of 35, I was discovered to have a arterial block in my aorta.
Okay.
And in medical parlance, that would have given me only 5 to 10 years to live.
Okay.
Aorta, as you know, is the entry point for the blood to enter the heart. Your Honor, I took care of myself for 2 years. I was able to do a lot of things, even using statistical measurements and graphs. And on my second year, which I was 37, I underwent my second executive checkup. And surprisingly, I passed the treadmill test.
Okay.
And when I was looked into, even my cardiologist, a Tomasian doctor who was the first woman president of the Philippine Heart Association, said, I don't believe this. How can you ever pass a treadmill when you have that problem? You know, about a couple of years after that, I again underwent examination at the Makati Medical. They did not find the block in the heart.
Okay.
And so when I was bypassed in 61, the cardiologist said, are you still alive, Dean? Because at 35 years, today, Your Honor, I'm running on borrowed time, and so if you ask me how is my health, I still feel good. My medications are okay. I exercise. I cut down on the eating during the Christmas holidays. I have not gained much weight. So I think, Your Honor, I am as healthy as anybody of my age.
Okay. As you have stated, you are running on borrowed time because of your heart condition. Do you think your heart can survive the pressure which you will surely encounter if you will be fortunate to be nominated and appointed as a member of the highest court of the land?
Your Honor, very, very interesting question about stress management.
Okay.
I learned at an early stage that managing stress is really using your brain and your system. If in a stressful situation, like this is a stressful situation, the real technique here is to scale stress in a scale of 1 to 10. And when you reach the level where feeling 5 or 6 already, you should simply say, hey, relax, stop the stress. Now, if you say that the practice of law and in the Supreme Court there is stress, Your Honor, let me just share with you that the private sector stress is worse because the pressure, especially on my part as Chief Finance Officer, to meet payroll, to pay suppliers, and all of these stresses has been a bread and butter for me. And yet, in those 45 years that I was subjected to stress in the private sector, I was myself a practicing lawyer appearing in court. And I was also teaching at the College of Law. I was also teaching in the graduate school. So the multitasking, Your Honor, has always been there. And so I guess stress has been part of me. I can survive the stress.
I see. That's a good outlook. Okay. Now, I also observe that you are so active and very vigilant in the workings in the Supreme Court. No. Now, in certain cases, there have been conflicting rulings and views made by the Supreme Court. As a long-time practitioner, what would you suggest to avoid such conflicting rulings and views?
Your Honor, this is a matter of managing the database of cases, because we know that many cases have already been resolved, and the Supreme Court and the rules of court have built-in checks and balances, in that if, for example, a certain legal concept has been adopted in a decision, it is expected that becomes the jurisprudence in that specific subject matter. Now, so that if there is another division that would make a decision, it is fundamental in our rules of court that this particular decision should be reconciled. In fairness to the divisions of the Supreme Court, it is possible that an identical issue is presented, for example, to the third division, and after a few days, the same issues but involving different parties is presented to the second division, because the divisions really are autonomous in their own right. It is possible that the decisions there may run into conflict. And the funny thing is, it may even run with existing jurisprudence. There is a need for administrative management here. This is what I was saying. If you come from the private sector, that cannot happen, because you cannot have a program of promoting, for example, Tide or for example, Ariel, and on the other hand, your sales force is promoting another thing. That is mortal sin in the private sector management. It's a unity of command and focus on decisions. But I hate to say this. I always encounter situations, and I'm very fond of research, where you see two decisions that are definitely conflicting. And and they are recent decisions, and it can be shocking, and sometimes you lose out. Now, the funny thing about practitioners is they will cite the decision that favors their case and would probably remain silent about the other decision that doesn't favor the case, when the real honest move is to elevate the issue before the Supreme Court and highlight that there are these decisions. So in answer, how do you manage this? There has to be a management control system that screens off these conflicting views.
Okay, this will be my last question. Attorney Santos, what do you consider as your strength and weakness, both as a person and as a member of the legal profession?
My major strength, Your Honor, is the wealth of experience I got from it being in the private sector. And this is also tied up with the weakness that was already asked of me in 2012. Dean, you have never been part of the judiciary, so how do you expect to perform well as an Associate Justice of the Supreme Court? Let me combine this and say this is essentially a strength by its own right. Because if we have a battery of experts as trial judges that went up the ladder, essentially we're talking about a homogeneous set of associate justices who are seasoned with the procedural aspect of getting the cases flowing. Of course, I'm not questioning their expertise on substantive law, but if you bring in somebody who's totally not tied up to that system. I come from the private sector with varied industries: petroleum, energy, agriculture, pharmaceuticals, and electronics. And so if the objective is to speed up the cases, judges and justices who do not have their exposure on these industries will have to call on a lot of consultants. I can eliminate all of those because I already have the wealth of knowledge and experience. So this, even the in-workings, even on corporate law, I don't have to read the cases. The cases are available, but I know how the workings are inside, even the backdoor maneuvers in corporations. So I will understand, a lot of these cases that are presented. Now, why do we have a bottleneck of cases? If you look at even the trial court level, up to the Court of Appeals and Supreme Court, the accumulation of cases understandably will zero in on the areas where the judges and justices have no expertise. And so, what are these? These are essentially the mercantile law and commercial law cases that are not very easy to understand, from corporation law to banking, which is specialization, to transportation, to insurance. I bring with me 45 years of tested knowledge, working knowledge, in that I don't even have to study the industries anymore. I bring in and say, this is how the industry works, this is the conflict, this is how it is. And probably it's a collegial body. I will explain to the other four members, ganito po yung kilitian dyan eh. And so, there is no need to bring in any consultant because the other justices can verify whether I'm bluffing my way out on this one. So I carry with that kind of strength, Your Honor. Not to mention that this has been tested in the graduate schools of UP and LaSalle, where I've been teaching in UP 10 years, at LaSalle about 40 years.
Thank you. Question, and I wish you luck, Attorney Bisquera.
Marami pong salamat.
Thank you very much.
Ma'am, you said that in 2012 and I didn't get the luck, so I hope you say it better this time.
So thank you very much, Justice Lagman. And now it's my turn.
You know, it's a privilege to meet you again.
Okay. Dean, what took you so long before applying for the position of Associate Justice of the Supreme Court? Why only now?
Your Honor, I was heavily considered in 2012.
How many years ago? That was all. And what was your age then?
I'm 68 now, minus 65.
Why not when you were at 50, 55, or before 60?
Because, Your Honor, I passed the bar when I was 47. And after I reached the 5-year experience as a lawyer, the records of the JBC will affirm to this. I have been applying consistently for all the legal positions available.
At 57, you could have made a try. Anyway, I admire your proposed measures to dispose of cases with dispatch. But I think time is of the essence. You know, it is a fact, because I came from the Supreme Court, that although you are well versed in all laws, procedures, jurisprudence, but the inner workings in the Supreme Court are really different. And sometimes it takes 1 year or more for a new member to learn the ropes.
Yes.
So don't you think your time is limited, just in case you are lucky enough to be there?
Your Honor, I have experienced the same scenario in all the companies I've joined. Because when you come in at the senior level, even the
that is very, very different from the scenario I'm laying before you.
Posible po.
So,
Posible po, Justice.
napakahirap na po.
Posible po.
At your age.
Posible
But
po.
anyway, if you are lucky enough, let us see. Okay, you stated that one of the measures you are proposing is to get away with MRs, or motion for reconsideration.
Yes, Your Honor.
The Supreme Court, even when I was an MTC judge in Manila, had already promulgated a rule as far as the rule on summary procedure is concerned.
Yes.
MRs are prohibited.
Are prohibited.
But you know, sometimes at the level of the RTC, it's so difficult to get rid of MRs, because sometimes MRs have merits.
Yes.
MRs have merits.
Yes.
So we cannot absolutely eradicate MRs,
Yes.
as far as I'm concerned.
I submit to that, Your Honor.
Okay. Anyway,
Your Honor, my only side comment on that is, perhaps this is where statistics will come in.
Okay.
That if we run the cases that have been subjected to MR, how many, what's the percent of reversal of a judge decision that was subjected to an MR? And that would, facts would always speak for themselves, and mathematics will not lie if we run this particular system.
even during the time of Chief Justice Fernan,
Yes.
the Supreme Court had been promulgating rules
Yes.
to these post cases
Yes.
early. But then, will you agree with me that despite all the rules the Supreme Court has been issuing until now, still there is delay in the disposition of cases
Yes.
from the highest to the lowest level?
Yes.
And one of the reasons is, you know why?
No, Your Honor.
The personality of the judges themselves, if they are lazy, no amount
I submit
of
to that,
arguing,
Your Honor.
no number of rules, can move them.
Yes.
So, what is important is the support of the Supreme Court to see to it that justices being appointed are highly efficient,
Yes.
dedicated. Okay.
I can continue to hear Justice Gutierrez, whom I have heard repeatedly in the past, and you're still the same person, Your Honor.
Thank you. Anyway, just recently, the Supreme Court promulgated its decision concerning the case of Senator Enrile.
Yes.
If you were a member of the Supreme Court, will you concur or dissent?
To allow Senator Enrile to post bail?
Yes,
is
that was the ruling.
Yes. To be candid about it, I am bothered by the issue that has been brought to media on selective justice. What is fair for, in other words, I continue to believe on the personal...
Just answer my question then.
Yes.
Will you concur or dissent, and then reason out?
I will dissent. On the very principle that just because he is a special person, he should not be given a special treatment. He should be subjected to the same rules as, especially to the two other senators who are inside. And age should not be a consideration, Your Honor.
What else?
We already know the entitlement to bail is subject to conditions that it is bailable or not, and second, the degree of what they call this culpability, meaning the evidence is strong for conviction.
Do you think there was a defect in the procedure, considering that there was yet no hearing before the Sandigan Bayan? The prosecution hasn't presented its case against him. will not be that a ground for your dissent. Number two, don't you think the Supreme Court was not legislating, considering that actually it changes the provision of the Constitution that all persons are entitled to bail except those charged with an offense,
non-bailable offenses and the evidence of
punishable by the Christian perpetua and the evidence of guilt is strong. Now the Supreme Court laid how many grounds? Humanitarian reasons, old age.
Your Honor, I have read through the...
So when you dissent, just in case you reach the Supreme Court, make a wholesome, reasoning.
Unfortunately for this question, Your Honor, the dissenting opinion which I am expressing is that of Justice Leonen, who happens to be in the same panel in 2012, and he was the one chosen. So probably if I were the one chosen, there will still be perhaps the same dissent.
You could have raised other issues. Okay. Another question. If you are asked by the Supreme Court, if you are already a member there, if you are lucky enough, to recommend amendments of Article 8 of the Constitution on the judiciary. Remember, Article 8 pertains to the judiciary of our present Constitution. What amendments will you propose?
I mentioned already one in terms of the structure of the judiciary, Your Honor. I would like to have a clearer organizational line which are organized from the Supreme Court up to the level of the Metropolitan Trial Courts, where there will be vertical accountabilities. And so when we talk about the system of, because people always generalize the system of justice in the Philippines, very slow, unfairness, and so on, it becomes a generalized motherhood statement. To allow that to be more specific so that corrective measures can be done, let an associate justice of the Supreme Court to be accountable on each of the 14 regions and down to the Court of Appeals.
That is not part of the amendment of the Constitution. That is a part of the rules.
Pwede po, Your Honor.
Hindi. Rules yan.
Pwede pong rules.
My question is constitutional amendment. How about fiscal autonomy?
Yun po yung area ko kasi ako yung financeman
So, on that point, what will be your proposed amendment?
One of the proposed amendments is, I do agree that the judiciary should have total fiscal independence. And so, in the matter of the charging of docket fees and all the incidentals relating to management of cases, the budget department of the executive department should never interfere because they are co-equal branches of government, and the judiciary should be given absolute power in terms of its managing its financial affairs, Your Honor.
So the judiciary does not have to kneel before the COA, before the DBM.
The Commission on Audit, Your Honor, would see
DBM.
The DBM, I would like to take an exception that the DBM should not encroach on the funds of the judiciary. In other words, the Supreme Court and the rest of the courts can develop their own budget and, as envisioned, submit it to Congress and therefore allow that the detailed budgeting to be admitted as a presumption of good management and good faith on the part of the judicial process, of the judicial department. But to ration off the funds for the judiciary by the DBM is totally an insult to an independent branch of government. I don't definitely agree with the way it's being run right now, Your Honor.
Of course, there is a constitutional provision for that. But in practice, as of now, there has not been an absolute fiscal autonomy on the part of the Supreme Court. I'm sorry, but the warning is there. So thank you very much.
Your Honor, nakakahiya nga po kuminsan sa trial law, no? You go to the courts. My first few years of practice, I went into a court in Binyan, and it was so dilapidated. It's not the same now, but there was a time when we were hearing and dogs were crossing the Court like that because it was really a dilapidated.
Even the Manila courts are dilapidated.
Opo.
Thank you so much, Dean. Good luck.
Ma'am, can I just make a closing statement here? I am realistic in saying that 16 candidates for one position is very tough for me, especially to be blunt about it. I don't have political backing here. I don't have anybody backing me up, talking to anyone of the powers that be. As a question of my 2 years available, let me offer an alternative. I have been applying for a lot of positions in the judicial department and I have not been given the opportunity to even be a judge. So as an alternative, Your Honor, instead of just simply setting aside my papers, is it possible for me to offer my services at the trial court level? Give me the most problematic trial court in Manila and I will submit a commitment that if I cannot move fast those cases in 1 year, then consider my resignation accepted. That's the only thing I'd like to do, just to prove that I mean something in terms of accelerating the judicial process. Yun lang po. Just in case, sayang naman po yung papel na yan, maraming mabibigat na candidates, baka naman sakali. Okay na po siguro, kahit na hindi na Associate Justice, pagtsatsagaan nyo na ako, kahit na trial court. And then, ma'am, you can watch me kasi patagal nyo lang kilala si Din, kakantsawan nyo lang ako, Din, puro pambobola ka, mag-resign ka na, wala kang managagawa. I will accept that, Your Honor. Maraming mong salamat for your
Thank you, Dean. That's noted, and we'll place that on record.
Thank you. Am I done? Maraming po salamat for your time and your good questions.
Sino susunod?